Okay. Well, hi, everybody. Thanks for joining at lunchtime on an early summer Friday. I'm a relatively new Beacon member. I joined the Beacon organization in February of this year, and I'm glad to get to know a lot of folks, even though we've been in quarantine. I've been trying to attend some Beacon events, and I'm happy today to do this webinar and share some thoughts with all of you. As Zoe said, this webinar is really designed for interactive, so comments, questions, feel free anytime, just please jump in. We have a full hour and, glad to do it in that format. I have a few slides that I'm going to share with you. Zoe's actually going to help me with that. I think I have a glitch on my end, so she's going to advance. I have 4 or 5 slides only. But so glad to share some of that with you. And as Zoe mentioned, I am Assistant General Counsel and CHRO right now. Prior to that, I spent a couple of decades in law firm life, where I represented large, small, medium companies and worked with labor relations and human resource professionals. So this particular presentation is one that some HR managers asked me to develop. It's about 10 years ago. And they said, how do we get our teams, our HR teams, our operations teams, just to do things a little bit better? Like, for example, do a little bit better on performance evaluations, do a little bit better on documentation for disciplinary purposes. How do we get them to do a little bit better on following policies or revising policies or adhering to policies? And they said, how do we make this real for the managers? So I put my thoughts together, and over a summer, about 10 years ago, I developed a program. So today's kind of a shortened version of a 2-hour class that I presented many times, and I call it Managers Under Fire. And the basic premise for this is, oftentimes, managers, whether they're HR or operational folks, proceed with discipline and sometimes termination, but there's a lot of faulty information underneath it, and it only gets exposed later. And so to make this real for managers, I showed how sometimes the uncomfortable conversation sometimes turns on them. And I used the example, and this is something, and Zoe, you can go to the next slide. This is something that I've experienced, I would say, probably 50 times in my career. And it's a pretty simple example, and many of you probably had a similar or related situation. You terminate an employee, and all of a sudden you're in front of maybe the EEOC because they file a discrimination charge, or you're in front of a labor arbitrator if there's a union involved, or sometimes you could be in court. It could be federal court, it could be state court, and say the employee's claiming age discrimination, that the termination was improper because of age discrimination. And oftentimes what happens is you get in front of that neutral outsider. They don't know your company, they don't know you, they don't know the manager, they don't know the terminated employee. All they know is what they're being presented with initially. And sometimes the initial presentation, it doesn't always look so good for the company or the manager. And what do I mean by that? Sometimes you have a termination letter that talks about poor performance and bad attendance, and therefore we terminated the employee. But then you get to this neutral arbiter, and it could be an EEOC mediation judge, arbitrator, whatever the case may be, and they start hearing from the attorney for the terminated employee, and they start hearing, well, Mr. Arbitrator, or Mr. Your Honor, the judge, it's not exactly what the company's telling you. There's other employees who had similar performance problems or similar attendance problems, and they didn't get fired. And many of them are younger than my client, the terminated employee. Or, Your Honor, let's take a look at these performance evaluations. This person's been working here 10 years. These evaluations all say he or she has been doing a pretty good job. Matter of fact, some of them say been doing an excellent job. Your Honor, let's take a look at some other things. There's really no track record or discipline. This termination letter came out of the blue. and my client's really surprised by it. There was no prior warning, there was no suspension, there was no progressive discipline. And something else is really strange, Your Honor. When my client got terminated, the manager who works very closely with my client, who used to work very closely with my client, she was saying, I always liked working with you, and I always thought you did a good job, and you really supported me, and this wasn't really entirely my decision. So that's like an example of sugarcoating. And, it's a natural human reaction in some ways, because it's an uncomfortable conversation. For those of you who've had to terminate employees, it's not a fun conversation. And some people are better at it than others and maybe don't like the confrontation, so they resort to sugarcoating, which sometimes later comes back to haunt them. So let me just fast forward a little bit. So now you're at this meeting, and I've been at this meeting, and I've represented many HR managers and companies. Now all of a sudden the judge is telling you, or the arbitrator is telling you, or the mediator is telling you, you should really take a look at settling this. If you give the person, I'm just making up numbers, $25,000, $50,000, $75,000, we can settle this claim and avoid a trial, and let's move forward. So now here you are, HR manager, operations manager, plant manager. You have to make phone calls back to senior management. Now remember, you probably just told senior management months ago when you fired this person, and that's why I wrote on here, slam dunk, right? I'm going to rebut that later. But you said, the evidence is clear. This employee, DiNome, was a really bad performer for many years, and then all of a sudden it got really bad, and the attendance problems escalated at the end, and we had no choice, and we fired him. And now you have to explain to the owner of the business, or the president of the business, or the division president, whoever you have to report to, why is a judge saying we need $50,000 to settle a case? I thought we had a strong case. And then you have to start saying, well, our documentation wasn't very good, our performance evaluations weren't very good, blah, all the things that I just mentioned, right? And now the focus turns to HR, or the focus turns to the manager. Well, why didn't you have better paperwork? Or when you were telling me this was a good termination, did you think the paperwork was good? Or do you only think about it now? It raises a lot of internal questions for management that are uncomfortable, because now somebody's asking to write a check, right, for 50,000 or 25 or 250,000, whatever the case may be. So these uncomfortable conversations are the ones that I like to relay to managers to kind of get their attention that, this is not just about the company. This could be about you. You're now going to be exposed as perhaps not as diligent an HR leader or generalist or plant manager or assistant plant manager or whatever the case may be, and that your reputation could be on the line. And the good news is I have some tips in my 2-hour class, which today will be a 20-minute class, on how you can do things a little bit better. So that's the big focus that I'm taking for this particular class. And many of you are either smiling or some of you are saying yes, because you've been through this. And I hope we can have some good dialogue about, hey, what can we do better? So I've identified it, and so you can go to the next slide. So I've kind of broken this out into a couple of areas really quick that I'm going to hit. And this is like really quick, because this hiring process can be in itself a full 1-hour class, right? But we'll just hit a couple of highlights and then we'll go to another topic. But I recommend that you take a look at your entire hiring process and do an A to Z review. Because you know what many people say, how do you avoid firing bad employees? I'll put bad in quotes. How do you avoid that situation? Well, never hire them in the first place. Now, of course, we all know that's easier said than done, right? There's always going to be the 5% or the 10% that you may have to weed out for either performance or other disciplinary type issues. But as a general matter, I think it's always good to take a look at your hiring process. So I recommend take a look at your applications. Are you getting the information you need? Is the application asking any illegal questions? Asterisk, footnote, conviction questions, right? That's become an area of scrutiny. So that's something you want to look at. Take a look at your social media footprint. Which avenues are you using to advertise open positions, LinkedIn, other things? train the interviewers. I can't overemphasize this, and this is really where sometimes you do need a full hour class about training them to do the job that they're supposed to do. It's not supposed to be simply a conversation about the Phillies or how great it is to live in Center City or in Malvern or wherever the case may be. That's part of it, right? You want to get to know the potential future employee. But you also want them trained to be able to pick up on things about the ability of the individual to do the job that they're going to be hired for, to fit into the organization's culture, and to kind of evaluate whether they're just going to be a good hire or a bad hire. And that's where you do have to trust your instincts. And I think with some training, because you know what happens sometimes, some interviewers, two things happen. They either get lazy because you're really short-staffed and you just need a warm body. So then anybody who shows up for the interview, they're ready to hire because we need warm bodies and we're so short-staffed and everyone's working overtime. We need to fill it, and they make a rash decision. The other thing that happens sometimes, other interviewers are timid because they're afraid of asking an illegal or improper question because they've heard stories about, you can really get in trouble on an interview if you ask that question the wrong way. So what happens is they ask no questions, right? Or very few questions, and then they don't do the job that they're supposed to do. So training of interviewers to get them confident about what they need to do and about what they should avoid and whatever traps or pitfalls are out there, you create more confident interviewers and they actually can do a better job for you. So I always recommend training interviewers and not just assuming everyone can do an interview, because the reality is not everyone can. And some of you may have experienced that over the years. So training is I think, helpful. Trusting instincts. So, you always hear the horror stories about the person that looks like they just got out of bed and they've been drinking all night. And the reason they look like that is because they really had been. And they show up for an interview like that. And, people are like, there just seems something off about that woman or that guy. And, it's a little weird. So you always think, hey, if they showed up for the interview that way, how do you think it's going to be after you hire them? A lot of that performance and actions do get replicated. So don't be afraid to trust your instincts. Don't be afraid to ask about gaps on a resume. If you see a gap, 2 years, 1 year, ask about it. There's most likely a very good explanation, and but it's perfectly fine to ask the question, and you should always ask the question about gaps on a resume or any other questions on the resume that are essential to the job, like if a certain degree is required, high school, college, or otherwise, a certain license or certification, ask about it. If it's not on the resume, ask about it. Or if it is on the resume, ask some details about it, ask for background information on it. There's nothing wrong with doing that, and you should be comfortable doing that. And then the final piece is use the probationary period if you have one. Many companies have probationary periods, 60 days, 90 days, excuse me. And sometimes it's 90 calendar days, sometimes it's 90 working days. Understand what your probationary period is. And if you have unionized employees, the use of it is even more important, because that in many ways does become, I don't want to say it's a free pass, because there's nothing free in labor and employment law, but it's pretty close to it. Labor arbitrators will really defer to a company in the probationary period. And oftentimes, matter of fact, maybe just raise your hand. How many of you have unionized employees on this call? Anybody? Okay, one person. Okay, well, two. So, but it's good background for you to know that if you have unionized employees, oftentimes your labor agreement will have language that a termination or discipline within the probationary period is not grievable. So it really does become a true free pass in certain situations in your labor agreement. For those of you without unionized employees, this is what you should know. A mediator, a judge, or other neutral individual, if they see somebody being terminated for tardiness or absenteeism in a probationary period, you have that case on your side. That's not I don't want to say it's a true free pass, but the deference will be given to the company during the probationary period. So while you have stricter rules in labor agreements about use or non-use of probationary periods, even in the non-union world, there is some deference to companies that use it during that 60 or 90-day period.
So John, this is
Yes.
Janet. What I tell my managers is, yeah, I know we have a probationary period, but it isn't a free pass. You still have to document the performance. So a lot of them have said to me, well, their performance, we're in the the probation period, so we can just term them. And I say, upon what? Upon what measure are we terminating them?
Right.
So
yeah, that's a great point, Janet, because you know why that's important? And Janet's making a great point. Under the union agreement, you can terminate them even without the documentation because it doesn't allow them to grieve or arbitrate. But that same employee can still file a discrimination claim. And without the documentation, so maybe you win on the union labor agreement piece, but you still face the same challenges. So that's a great question, Janet, and a great point. So you still want to do your documentation even in the probationary period and even for a unionized employee, because there's good reason for that. And it's just good practice generally, but that's how the line kind of splits on that. The labor agreement versus what I'll call PA, if you're in Pennsylvania, under the Human Relations Commission or potentially EEOC. Barbara, were you saying something also, or?
No, I was yelling at my husband on mute, sorry.
Okay, fine, good. All right, that sounds good. All right, Zoe, you can go to the next slide. So let's see, fair employment policies. These are kind of what I call the overarching pieces, and each of these would require a fair amount of discussion. But progressive discipline and equal treatment are really important drivers when you're looking to support a disciplinary/termination decision. If you have progressive discipline, and of course, there are some instances where you don't need progressive discipline. If somebody, for example, violence in the workplace or certain sexual harassment or certain other, they call them cardinal sins in some policies or some labor agreements, you don't have to have 3 examples of that or 3 instances of that. But by and large, for certain performance issues, for attendance issues, misuse of sick leave, etc., you generally need a good policy in place and you need a good track record of progressive discipline before you're going to terminate somebody. Performance evaluations, this is where I can go on and on and on and on and on, and I won't. I generally say, on one hand, as a lawyer representing a company, I say, get rid of all of them, throw them away and never use them. As an HR professional, I see them as a valuable tool. And let me tell you why I have this split in my brain. I've been in too many cases where the performance evaluations do not square up with the company's view of that employee. And the reasons for that are innumerable. Managers are lazy. I'm including myself. I don't necessarily like sitting down and doing performance evaluations. You look for shortcuts. You don't want to hurt people's feelings. You want to get your people a bonus or a step increase. So you don't want to hurt them on the paperwork. So you tend, me included, we tend to overrate or over-evaluate our employees and don't always write down problem areas. So if there's one thing I can say about performance evaluations before you all go throw them away, is if you can train your managers to just do them a little bit better. And what do I mean by that? You can have an employee who's doing a very, very good job, but there may be a certain problem area, such as tardiness, or such as absenteeism, or such as maybe there's a certain report they have a problem with, but on the other 90 things they do, they're doing a fabulous job. But it's important for you to put that on there for a couple of reasons. One, it truly could help the employee do better. Right? It doesn't mean that they shouldn't get a bonus. It doesn't mean that they shouldn't get a step increase. But if you note it on there, it could help the employee, could. But it certainly can help you as an HR professional or operations person. And what do I mean by that? Go back to that settlement conference. If you could note on there that even though this person's been with you for 10 years, but you noted on there that, over the years, there's been a consistent absenteeism or tardiness problem, it takes away the ability of the lawyer for the terminated employee to tell the judge or tell the arbitrator, you know, Mr. Arbitrator, I think the company's lying. And the real reason must be age discrimination, because the story they're telling you that this person's had a problem for many years, how come it's not on any of these evaluations? These evaluations, Your Honor, these are the company's documents. We didn't make these up. They were writing these things down. How come they didn't write down in 2015 the person was having an attendance problem? How come they didn't write down in 2016 the person was, the documents don't say anything about that. So they must be lying, and it must be age discrimination. So now if you're the judge, they don't know you, they don't know the lawyer, they don't know the employee, they don't know anybody. All they know is what they see in front of them, and they're saying, you know what, guys, your story's not matching up. You have a real weakness in your case. Go get $50,000. You know, I'm back to that settlement example again. So this is why I tell managers, just do them a little bit better. You don't have to go to 20 classes on evaluations of employees. Just do them a little bit better and note if there's a problem. And so that's my big takeaway from this shortened version of what do you do about performance evaluations? Because I'm going to tell you, they are a huge problem in labor and employment cases, a huge problem for the company. And usually I'm sitting there at 10 o'clock at night getting ready for a hearing the next day, and I say, you know what, I wish I could burn all of these, because all they do is hurt your case, because it's documents that HR and the managers created, and now I have to go argue why they didn't make a note of this, and it's very hard to explain, extremely hard to explain. Irv, you had a question? Go ahead. I think you're on mute. Irv, you're on mute.
Thank you.
Here you go. Hi.
Hi there. I think your presentation is clear and precise. I see an issue in COVID-19. As an employer, all of our employees are in isolation operating from their homes. And I think they're very efficient. My perception is that in terms of serving our clients, I'm CEO of a wealth advisory firm. Very high touch, partnership type relationship with our clients. From that perspective, I feel like as the employer, I'm getting good value. But since I can't see them, I have no way of knowing whether their typical workday, which is, let's say, 8 to 10 hours, typically, including commute time, is being used very efficiently or very inefficiently. And as you're talking about documenting the observations regularly, especially on a new employee, I would ask you to expand that thought to, let's assume that isolation type format continues, and we have, whether it's all employees or some of them, what are the tools, and maybe you're going to address this later in your presentation, so that we can not feel like they will not feel like we're watching them, but at the same time, we have a sense of accountability, and we know whether we should be making notes on certain employees that aren't pulling their fair share.
Right. That's a great question. And it's one that we have to grapple with, and many employers have grappled with that already, separate from COVID, if they have put in place work at home policies. So there's two pieces that we have to think of. I think for 2020, since this is such an emergency and different situation, I think in many ways employees, just like a lot of kids at school, are getting a free pass on finishing out their semester with pass-fail. I think for 2020, you have to just almost give employees kind of a pass-fail and a little bit of a pass as long as they're doing their basic job. However, that doesn't mean going forward, if this really becomes the new normal, and you hear a lot of people saying, hey, this is going to be the new way of work and employees are going to work from home, then I think you do have to look at two things. One, for employees that are being paid by the hour, meaning they're not exempt, they're non-exempt, so they're eligible for overtime, you have to find a way to track their workday. Otherwise, in the absence of employer records, any claims that they make for overtime later, the company is going to lose. So you have to put in place processes and systems for them to log on to an electronic system, whether it's a phone or a laptop or an electronic punch-in. And then you have to find ways for their managers to check in with them throughout the day. And these are things that many companies have already done in the past for work at home arrangements. And then you also have to have policies that when their workday ends, say it's 4:30 or 5 o'clock, you have to tell them that they need to stop working unless they have permission from their manager. Because otherwise, if they're still checking emails, and remember, this is an hourly employee, not a manager, not an exempt person. If they're checking emails at 7:30 or 8:45 at night, that all needs to be compensated. And you don't necessarily want to be paying them to just check an email at 8:45 if it's something they could do the next day. That's one piece of it, Irv. And I know I'm not completely answering your question because there's a part two to this. For all other employees, you need to develop, maybe not as defined as I just mentioned, but you have to find a way for them to be able to check in and log in or call somebody or electronically get a date stamp that they've started a workday at 8:30 in the morning or 8 a.m. because that's their first client phone call or their first client Zoom, whatever they're doing. You have to find ways to check in with them and get reports, most likely every other day, about tell us what you did, tell us about your interactions, tell us about the timing of it, so you have a sense that DiNome's workday was approximately 8:30 to 5:30, and he took an hour for lunch, and he took a half hour to go watch his kid's soccer game, or whatever what I would normally do from my office, that I kind of did the same thing from home, as opposed to, yeah, I did something at 8:30, but nothing again until 2:30, and in between, I was, reading a book in the backyard. So you have to find ways, and you have to have hard and direct conversations with your employees, because you tell them, look, if we're gonna let you work from home, but I have to have some assurance about what you're doing while you're home. It sounds a little bit intrusive, but it's, at the end of the day, is to create a good comfort level and conversation between you, the employer, and the employee. And then, Irv, that would become the basis for evaluation about what they're doing. You could have an employee in your office goofing off all day too, searching the internet and watching baseball games on their laptop. So, you do have similar problems in the office, but it is certainly exacerbated when they're in their house. I hope that helps. There's not a cookbook answer to this, but there are answers to it.
John, just a fast response to that. We've been approached by companies saying, we'll put a camera in your employee's home, which offends my sensibilities. I don't want to be in a position where I'm watching them. I've also heard about, like you said, an electronic check-in. I don't think it really addresses the issue, because let's say that they check in at 8 a.m. when we start. Well, and let's say that they check in at lunchtime. Now, we have a Zoom meeting every week with all team members, and they're all over, which gives us a sense of camaraderie and connection. But even if they check in the morning and the end of the day, it seems to me that what should be coming, and maybe you're aware of this with your expertise in the legal field, but something where we can see work product. Because as fiduciaries, we already expect each team member to conduct themselves well and to put the client's interest ahead of themselves. So that's not an issue. That's actually a mandate.
Right.
But as far as the hour to hour, did they take an hour off to go lay in the backyard? I have no idea. So could you comment about systems where there's a tracking of work? For example, a tracking of emails might be useful, or tracking of phone conversations, and integrating that into some form of package.
Right. So you can do all of the, and I'll address the cameras also, but you can do all of the above. And just like you can't really control whether a manager is goofing off for an hour doing online shopping in his or her office, you probably won't be able to monitor whether they're goofing off an hour in their backyard. But what you can do is you can place stringent demands on your managers and the employees performing the work to give you a log of what they did each day. And this is really even more important if they're working from home. So what you do, Irv, is you combine two things. The electronic check-in, which creates a little bit of a date and timestamp for the start and end of the day. But it also then, you marry that up with the report. Today I called 18 clients. here's the follow-up, here's the follow-up emails, here's the follow-up trail, here's the documents I sent them, I have an appointment scheduled for next week. So in many ways, it's an exacerbated model of what you would maybe do if I was coming to work in the office. You would want similar analysis of some work product. You know, DiNome, what are you doing all day sitting in your office? Even though I know you down the hall, what are you doing, right? So in some ways, it's not that much different, although it's harder because you're not seeing me at all. You don't see me come in, you don't see me leave, you don't see me at lunch, you don't see me when I leave for my kid's soccer game, and you don't see me when I come back because it's all out of your sight. So you need a little bit more documentation, but in some ways, it's no different than what you should do already. Cameras, don't do cameras. Even cameras in the workplace are problematic from a privacy standpoint, as well as potential other claims. So even putting a camera in an employee's office is not a good idea. I would not recommend that you put it in someone's home.
You know, I respond well to what you just said about keeping a log. And the way I see it, if you talk about cameras, and as I said, that already offends my sensibilities. It's just not an appropriate expectation, nor I wouldn't want them going throughout their day going, someone's watching, right, even if it is, you know, the company. But what I liked about your having them create a log, it puts the responsibility in their lap. I'm paying for the time to create that. It doesn't go to other team members. It only goes back to senior management. And there's several of us in senior management. And everyone's on a level playing field. If they're all doing it, then it also gives you a log to protect yourself from some form of, you know, if there was litigation at some point, you have the backup to demonstrate what they said they were doing. And if you found at a later point that they didn't actually do it, then you can establish what's the gap and be able to point to it with specifics every day, which I would assume would strengthen your legal case as well.
Absolutely. Yeah. So I think that's probably your best approach.
Thank you.
Good. That's a great question. Just two more quick thoughts on this slide, then we'll go to the next one. For those of you who have union agreements, I think it's Carol and Janet on this call, obviously know what your agreements say, know the track record, know the history, know if you had arbitration awards, know your negotiating history, and then that could help you apply the terms of the agreement to a particular situation. Once again, of these 4 topics, that's a whole nother hour, 2-hour class right there. But I'll leave it at that for right now. And if there's some questions later, I'll answer them. The final point, public-private sector. Is there anybody here who's an employer in the public sector? All right, it's not, probably not. But if there were, then there's different concerns for public sector employees because you would be covered by the US Constitution and have certain First Amendment rights and certain privacy rights. But I won't go into that now since we don't have any public sector employers. So, but leave it at that. That if you had that situation, there are some distinct differences to be aware of. We could do the next slide, Zoe. All right. So, discipline and termination. You know, at the end of the day, 3 things come up constantly when an employer's decision to discipline or terminate is being scrutinized. And that could be in litigation, it could be mediation, it could be arbitration, it could be a lot of different places, EEOC, et cetera. They'll want to take a look at 3 pieces of these 4 that I have on here. Was your rule reasonable and was the penalty appropriate? Did you investigate? We talked about the slam dunk earlier. I'll come back to that. And the final one is equal treatment. That usually drives all of the trains. If there are examples of other employees engaging in similar misconduct or poor performance, and they were not equally disciplined or terminated, you will most likely lose your case. That one stands out like with 20 asterisks. So if you have any kind of case, it could be in front of a labor arbitrator in a union matter. If you have other union employees that were not treated the same, you will most likely lose that labor arbitration. That's probably in the high 90s you're going to lose. If you have other employees that were not treated similarly for attendance or tardiness, Ross, I'll be with you in 1 second. And you're in front of a judge or an EEOC mediator, and you have other employees that were outside of the protected category. Like, for example, in my example before, it was age discrimination, but you have younger employees that were not disciplined, you're most likely going to be getting your checkbook out and writing that $50,000 check or whatever the dollar amount is. The middle piece, the fair investigation, this was what I called when I first started the slam dunk, right? And this is sometimes laziness and sometimes just a little bit of bravado on the part of maybe HR or managers. They feel like, you know, I've known this guy DiNome for 10 years. He's a little lazy, he's a little sloppy in his performance, and now his attendance has gotten out of control. So what happens is, once you get to the end of the employment relationship and my attendance problems have gotten so bad, you fire me. But what you don't do is you don't do an investigation sometimes, because you figure, hey, this is a clear case. He's a bad employee and now his attendance is horrible. We have to get rid of him. But then later, when you're in front of the neutral person, they ask you, well, did you investigate why DiNome was absent all the time at the end? They said, no, it violates our policy, Your Honor. He's a bad employee. We got rid of him because it was a slam dunk. You don't tell the judge it was a slam dunk, but in your brain, it was a slam dunk, right? But the problem is, either because it's true or because I now lie about it, I say, well, the reason I was absent so much at the end is my mother was dying of cancer, or my brother was sick, or my kid was this or the other thing. And you don't have any evidence to either prove or disprove that, because you never investigated, you never asked me, and now I'm telling the judge all of this. And maybe it's true, or maybe I'm exaggerating it as the terminated employee, but the problem is you never investigated, so you can't tell the judge that you ever investigated, and you look like you're sloppy. So once again, the focus goes on HR and the managers again, because now the judge is telling HR, you're a sloppy HR department because you didn't investigate this. And all you're doing is sitting there steaming, knowing that DiNome is probably lying about this or exaggerating it, but you can't disprove it. And now you have to tell your boss to write a check. So you're steaming, and you yourself are under scrutiny. So I'm just kind of highlighting the same thing again, but it's important to investigate, even if the investigation is 10 minutes or 10 hours or 10 days, always do an investigation for every termination, always. And like I said, it could be a quick one, but always do one. So you could always say later, Your Honor, we did investigate, we called DiNome in, we asked him why is he absent so much, he couldn't give us an answer. He had no excuse. Whatever he's telling you now is a lie, he's making it up. And at least it allows you to stay in the ballpark to rebut the story. So these are all important to stay focused on. This list is really, there's really a list of like 7 reasons. They call them the reasons for just cause. But these 4, and particularly the 3 I highlighted, are the most important. Now, somebody said they had a quick question to jump in.
I have a bunch of questions, but they're not completely related to this exact thing. Will there be time at the end?
Oh, yeah. Does somebody have a question on this? Ross, you said you had a question, right?
I do, but it's not related to this either. Barbara, why don't you go ahead of me?
John, do you want me to wait until you're finished?
No, go ahead. No, go ahead. Let's just do it.
I can get a little tiny bit of background on the situation. I'm a very small company. And last year we took on a J1 visa employee.
Okay.
She's leaving this week. It's like a fixed thing. There's no visa renewal. As you know, they canceled H-1B. Like there's no chance that she can stay. But I have several clients that want her to continue working on their projects as a contractor. But she has to go back to Ireland. She can't stay here. I guess my question is, can I pay her as a contractor? If so, what does that look like? Am I depositing into a foreign bank account? She does have an American bank account. Is she going to get double taxed? Like, do you deal with stuff like this where?
You know, I am not an immigration attorney expert, so I won't claim that, but I will tell you that you can engage foreigners as contractors. They will most likely be subject to tax in both jurisdictions. But if you pay them as a contractor, you can simply report it on a 1099 here, and that would subject them to U.S. taxes. They would have, you would then have to find out what you need to report, if anything. Did you say Ireland?
Yes.
Yeah. So I would suggest that there is a way to accomplish that, but you should get an immigration attorney.
I should. Okay.
Yeah.
And,
I that's not an area that I particularly, can claim expertise in.
okay. And then quick follow-up
Yeah.
related question. So because she was on this special internship visa program, I got her at a high discount, very fair wage, but discount for what she was doing. So I can't afford to replace her with a normal full-time person, but I don't want to go the J1 visa route again. I'd like to do some kind of like hybrid commission style position where I say, okay, I'm going to hire a statistician. They're going to get a base salary guaranteed of like $30,000. And then you get 30% of all revenue from other client work that you work on. So it kind of protects me too, in case we hit a slump, because we're a consulting firm, I can't guarantee any work is going to come in. Is this a risk? Have you dealt with these types of agreements?
Yes. That area I've dealt with quite a bit, and I could talk to you even, offline after this seminar. But yeah, you can certainly do that, and you can structure it with a base salary as long as the base pays minimum wage, which sounds like it would. Yes. Then it complies with the Fair Labor Standards Act as well as Pennsylvania. Is it Pennsylvania?
Yes.
Yeah, as well as Pennsylvania law, and then you could always structure the commission on whatever you can negotiate between you and the individual, and pay them a commission on whatever task it is you need them to do. And that may be a way to kind of skin the cat on that one.
And I assume that would require a separate type of employment contract that you could.
Yes.
I could pay you to write, for example. You do those. Yeah,
I mean, I can get you a lawyer to do that. Right now, since I'm working for American Academic, I really can't engage in outside legal work at this time.
Okay.
Maybe in a few months you could talk to me about that, but I could get you a lawyer to help you with that.
All right, great, thank you.
Okay, good. All right, Zoe, let's go to the next slide, and I think it's the last slide that I'm going to cover, and then we'll do all questions. So I'm sure many of you have done discharge meetings, discipline meetings. You could raise your hand for those of you who have done them. I recommend you keep them brief and to the point. That particular meeting is not one where you want to discuss the Phillies or discuss the person's family. I'm not saying that you're going to be uncivil or mean about it, but the meeting needs to be short and to the point and directly about the bad news. So these are not easy meetings. They oftentimes, like I said earlier, they lead to sugarcoating for people that are uncomfortable with these meetings, and they want to talk about everything except the termination, or maybe blame the termination on someone else. And you'll remember what I said earlier, those meetings often get replayed because this is usually, and I know I only represent companies, so I'm on the company side, but I know many lawyers who represent individuals, and they always say, the first question they ask when a terminated employee comes into their office or calls on the phone, they always ask them, the first question is, what did they tell you when they fired you? First question. It's the very, very first question. Then they'll ask them 100 more questions after that. But it's always the first question. And if they get a kooky story, like, Mr. Lawyer, the meeting was weird. All the guy talked about was the Phillies and the barbecues and how much he loved the great work I did over the years and how he hated firing me. It was a really weird meeting. I don't think they have a reason to fire me. And the outside lawyers love those kind of stories because they're going to use that to kill the company later. They love that. So you have to make sure that just like I said, train your interviewers. Don't assume that everyone can terminate an employee. It's not easy. For those of you who've done it, it's emotionally difficult. It's intellectually difficult. You have to bring your A game to it. You're representing not only yourself, but the company. And those conversations do get replayed later, and they're often embarrassing. So don't sugarcoat. And the last thing is, after you fire somebody, limit the information to those with a need to know. I'm exaggerating here a little bit, but obviously you wouldn't want to post it on your social media or your website. Hey, guess what we did today? We fired DiNome, right? I'm exaggerating. I'm not saying anybody would do that, but you have to be careful that you don't do similar things in the lunchroom or in the break room or at the meeting at the end of the day. That information oftentimes does need to be shared because you need to let your customers know, you need to let coworkers know, you need to let vendors and suppliers know DiNome is no longer with the information, but it should be presented in a very formal in an official way and not just word of mouth, because you know how word of mouth goes. It never goes well. Somebody's going to say the wrong thing and they're going to say, yeah, they got rid of DiNome because he was a lousy employee or because of this or because of that. And now DiNome hears that or hears this from customers. And then when he goes to his lawyer, when I go to my lawyer, I'm going to say, and guess what else they're doing? They're bad-mouthing me all over the state. So then it raises what I call a potential defamation lawsuit against the company. Those are usually weak cases, but it adds to the arsenal that the employee's attorney has to squeeze more money out of the company. So you want to show that, no, you did not do that, that the communication was official, it was in writing, and here's what we did, Your Honor. We sent a letter and we said, Mr. DiNome is no longer associated with ABC Company. If you have any questions, please contact X. We did not say anything more or less about DiNome, and whatever he's telling you is nonsense. But if you don't have a controlled method for the information, it opens you up to the defamation lawsuit. And then, and all that, and what that usually means is write a bigger check. So with that, that's really, I'm done. So we can fire away with some questions. So anybody who wants to jump in.
Do you see the chat question?
Do I do what?
Do you have, I wrote you a question in chat.
Oh, I'm sorry. No, I didn't read it, but I will. Paul, if a phone discharge, can you record? Should you record or have second manager present? Okay. So what state are you in?
Well, I work between New York, New Jersey, and Pennsylvania. So.
All right. Well, that's great. So what happens is most states require two-party consent for a recording. So you can record, but you have to get the consent of the other individual. So don't do it in private, because then it subjects you to a potential wiretap violation, which you don't want. So what I often say is don't record it, but always have a second manager present, either in person or on the phone, for any kind of interaction like this you're going to have with an employee, whether it's discipline or termination, and just have somebody else present. That's going to be your best practice generally, because you know why? Once you start this phone stuff, then the employees, they want to tape you, and then you don't want to be taped, and it creates this whole big tit for tat about who's going to get the recording and who has the best recording of it, and you left this sentence off, and my recording has more than your recording. I say no to all recording and just have a manager on the line. Irv, you had a contract question?
I do. In our agreement,
but you know, Irv, can I just give somebody else a shot before?
Of course. Absolutely.
Barbara, did you get to ask your questions?
Yes, thank you.
All right, fine. I'm sorry. Go ahead, Irv. Go ahead. Sorry.
All right. With our agreement at Pennsylvania Capital Management, my firm,
yeah,
I wrote it 20 years ago with the idea of making it as easy as possible for any client that wasn't totally satisfied to walk away with no cost and no, let's call them handcuffs. In this day and age, is that still the best policy? Meaning if a client sent us a note and said, for whatever reason, we're not pleased, we want to do it ourselves, you know, on the whole wealth advisory side. And we also help with what I call life transitions, because all clients go through a series of life-changing events, typically on a regular basis, whether it's
right.
kids or parents or whatever. My question revolves around, in this day and age, is there a better way to go in the wealth advisory field than that? Because my view was 20 years ago, when I started the firm, that you want to make it as easy as possible, and that since we are partnering with our clients, that if they don't view us in that regard, or they want to take it on themselves and take on that responsibility, they delegate it to us, that I wanted to make it as easy as possible at any moment to walk away with 5 days notice.
Yeah. I mean, I'll be honest with you. I don't really have a lot of expertise on the financial piece between you and your clients. If it was more related to your employees, I could help you. It sounds like a good idea. I like it. If I were your client, I like the idea of being able to walk away. So it sounds like a good thing. Whether that's the best practice on the company side, Irv, I don't have a good gut for that, and I'm not really in position to advise you on that.
If we were to evaluate the same question, but for employees, all of our employees are at will, which is typical
Yeah,
in the
in Pennsylvania,
registered
right?
in Pennsylvania, in the registered
And certainly in the
investment advisory.
financial community, right?
And I just was wondering, once again, from the employee standpoint, more of your specialty is keeping them at will both ways, meaning from them or us. I think my viewpoint is it's worked well. Most all of our employees have been with us a minimum of 10 years, and in some cases 15 years. So they like being here. And I think they're the best team there is because of the camaraderie that's developed
Right.
over that period of time.
Yeah,
So,
I think there is some beauty in keeping the at will, and then each side can walk away, quote unquote, at will, right? The only thing you would want to consider, and this would be for any employer, is that if there's a certain class of employees or managers that gain special training or special expertise or special information, proprietary information about your business, sometimes you do want to put a little handcuff on them in the way of a non-compete. And if you do that, it does raise the stakes a little bit, because maybe you're going to pay that person a little bit more. Or in Pennsylvania, there has to be special, what they call consideration for the contract to be enforceable for the non-compete. So oftentimes that means a pay raise or additional vacation or additional bonus eligibility. There has to be something in exchange for the non-compete. That's basic Pennsylvania law, but it's also the law in many other states. So that's the only thing I can advise you on that, Irv, is that you'd have to take a hard look. Is there certain people you want to put gentle handcuffs on? Otherwise, the answer to your question is I think the at-will works quite well.
just a quick follow-up.
Yeah, and then I want to get to Ross.
No problem. We have 3 certified financial planners on staff, and obviously we have to pay up to both get them and retain them. But I think that that goes in our industry without saying that you need to fully pay, if not overpay, the really talented team members you have who represent the link between your clients and competitors.
Yep.
Meaning, yes, they sign a non-compete, but also, the proper documentation that they will not take clients with them were they to leave. But I think going back to my 20-year-old perception, which is if you compensate them well and you develop a great spirit within the team of helping each other, as we act as fiduciaries, I think that's probably the best technique to keep the employees here and not going elsewhere.
I agree. If you can develop that right culture, then you can avoid what I call the technicalities of employment agreements or generally restrictive covenants. So if that's working, I wouldn't change it.
So there's nothing you would add, meaning you like that basic.
I like that
concept.
basic structure. If it's working for you, yeah. It doesn't always work in a lot of companies because sometimes you do need the restrictive covenants, which could be whether it deals with confidentiality or competition. Some industries you need that. It sounds like for you it's working, and you should probably just let it keep working.
Thank you very much.
Ross, go ahead.
Thanks, John. I'll try to be as short as possible. If you need more info, let me know. But
Sure.
If I'm an employer, if I make someone an offer, they accept it, they never show up to work and never tell me what's going on, would you report them to the Pennsylvania state for unemployment purposes to maybe cancel their unemployment? If they're if they're collecting it.
You made an offer, they never showed up, but then they're filing for unemployment?
We don't know if they're filing for unemployment. So I own and operate a staffing company. I place CNAs, LPNs, RNs. It's a brand new division for us. I never wanted to do it because of COVID. I had to do it. So
Right.
The fact that you work with hospitals might be helpful for
Sure.
insight here. I make an offer to a CNA to place on site with one of my clients. They accept the job. They never show up to work. They never call me. They never tell me. I'm sure you see this a lot. It's
Yes.
just part of the business. Are you personally, I guess, maybe what I'm asking is, are you reporting them to the state to say, we made this person a fair offer. They never showed up for work. I don't know if they're on unemployment, but if they are, please take them off.
Right. So, okay. So two pieces to this. Just because somebody rejects a job offer doesn't make them automatically ineligible for unemployment in
They
Pennsylvania.
accepted the offer. I'm sorry to cut you off. They accept the offer.
No, but even if you accept an offer,
Okay.
and then you decide, that doesn't mean that you're ineligible. But from your perspective, what you want to make sure is that they're not reporting you as the reporting employer. So hopefully you have a way of tracking that. Here's what I recommend you do, Ross. If somebody in that situation accepts an offer and never shows up to work, you write to them or email them or call them or all three. And you say, you accepted an offer, you failed to report to work, give them one chance to explain it. If you don't hear from them, write them a letter, write them an email, and call them and tell them that you consider the offer rescinded and that you consider that they resigned. So then later, if you do learn that they filed for unemployment, you'll have that email or that letter and you send that to the state and say, no, this person never showed up for work. We consider them resigned and the offer was rescinded.
Okay.
So just create that piece of paper, and it could be an email. It could be an email.
Great. Thank you.
Yep, that's the best way to handle that.
John, did
Okay, Barbara.
I was
Yeah, I
gonna-
think we have a few more minutes, Zoe, and then we'll have to, I think, cut it off out of respect for everyone's time. But
I
yeah,
was-
go ahead, Barbara.
if you were still willing to hang around like for a couple, did you mean like a couple minutes after it ended? Or you remember how you said you might be willing to chat with me about the?
Yes.
Okay, then you can end it. And do you want me to just hang around and
Yeah,
do-
yeah, that's perfectly fine. Joey, that'll work, right?
Yeah, that'll be fine.
Okay.
I did get one question from someone who wasn't able to attend, and it was about kind of with COVID and paid sick time and documentation, and what can you, as an employer, ask for in terms of documentation? What can you not ask for as proof that, you know, either someone had it or they're caring for someone with it?
All right.
Yeah.
So this would be, is this a CARES Act question, maybe?
Or just with I guess with COVID in general, are there different rules of, you know, you need to get documentation from your doctor that you have it, or what, or is there protections for the people that you can't ask for that?
Yeah, it's a good question, and the answers are the same. As for any protected leave, whether it's your sick leave, whether it's paid sick leave under a statute or the Family and Medical Leave Act, you are entitled to basic documentation from the employee's provider, medical provider, that they are in fact eligible for the leave that they're requesting. So whatever the standard is, if it's the CARES Act, if it's the Family and Medical Leave Act, or the expanded FMLA for COVID, or your disability policy, short-term, long-term, or FMLA, you can still require the documentation that supports the leave being requested. So you know, it's always that fine line between asking for protected medical information, but you're still entitled to, even with COVID, for the basic medical documentation that yes, I am out with my own COVID, or I'm caring for somebody with COVID and therefore eligible for this expanded FMLA leave, for an example, or under a local ordinance for paid sick leave, like Philadelphia has the paid sick leave as an example. So I hope that, I don't know whose question that was, but I hope that helps. But so the answer is yes, you can ask for documentation.
Okay, great. Did anyone else on the call have any questions before we say thank you and goodbye? No? All right. Well, John, thank you so much. I really think that hopefully that was
this was fun.
Insightful for a lot of people. And with a small group, it's actually good. People get plenty of chances to ask their questions. And thank you again. And I hope that you'll be a longtime Beacon member, even though you've only been around for a few months already.
I hope to get to meet all you guys. Maybe we can do a happy hour sometime.
Beacon is the premier executive networking organization serving the Mid-Atlantic region. To learn more, go to beaconforlife.org.